Sir, over the holidays, you filed a suit with the Supreme Court, but things happened. The anchors were released. I think you dropped that case, but
no, we did not.
You did not.
It was a case of they were released simply because the petition was filed.
Okay, so it doesn't render it moot.
No. It was in fact not just a petition for habeas corpus, which would have been rendered moot with the release, but it was coupled also with certiorari, which is an allegation of grave abuse of discretion amounting to lack of jurisdiction. Because number one, they could not compel Eric to reveal his source pursuant to the recently amended SOTO law. And number two, they were not accorded due process. The Supreme Court had only recently ruled on the Ong versus Senate Blue Ribbon Committee case. This is on the family investigation, where the court really said that you cannot imprison anyone by way of legislative contempt without according them the right to due process. And that's exactly what happened. Can you imagine? In the case of Lorraine Badoy, she was sent to jail because she gave allegedly conflicting answers as to whether or not her program had television ads. What is the relevance anyway of that question? And why would that be contemptuous to Congress? So I think, I'm hoping that the Supreme Court will actually continue to rule on it in the same way that it ruled on the Ong petition even after he had already been released.
What's your prayer there? Because in the Manila Times, we've written several times that maybe these congressional investigations go beyond the Constitution, right? Because sometimes when a witness is irritating the lawmakers, this becomes ground to citing them in contempt and throwing them in jail. And we were saying in our editorial, for instance, in the United States, Congress can only refer criminal action to the Department of Justice, and the DOJ will decide whether or not there's ground to file a case. And in this case, in the Philippines, Congress itself acts as, prosecutor, the judge, and the jury.
Executioner.
Yeah, and the executioner. Imposing, I guess even taking on the power to incarcerate whoever they want.
You see, the problem is, as early as, time immemorial in jurisprudence, we've recognized that the power of legislative contempt is actually necessary for Congress to conduct investigations. But there's been limitations since the case of Bengzon. And Bengzon said when a case had been already filed, whether be it in court or the ombudsman, I think in court, then you should stop because that's already a judicial function. But until the case is filed in court, they could still investigate because the power to conduct legislative investigations is plenary in nature. And only Congress can define what the purpose is, because it's plenary precisely. But in the Neri decision, the court also said, well, because due process must be accorded the guests or the witnesses in these investigations, you need, number one, to specify what the legislative inquiry is all about. And number two, you are even required to give the questions ahead of time to the resource person so they can have time to prepare. But what we saw in the House in particular really was they were being asked questions which were foreign to the subject of the investigation. For instance, this alleged criminal act perpetrated by Apollo Kibuloy, what relevance does that have on whether or not the franchise should be revoked when Pastor Kibuloy is not even a shareholder of SMNI? So we know that despite the directive given by the Supreme Court in Neri to narrow down the scope of investigation insofar as it is only necessary for a legislative purpose, that Congress has been wantonly violating this directive.
So what do you want the Supreme Court to do with regard to your petition? I mean, do you expect them to instruct Congress that this is your limitation, right? I mean, it becomes political in a sense. I mean, this is why we're talking about it now. I mean, we're talking about legitimate reasons of Congress to investigate matters, but when you throw in the political mix in the mix here, it becomes very questionable, right? When you take on certain actions such as taking away people's liberty.
Well, Lorraine and Eric were imprisoned for 1 week. And they want their rights to be vindicated with the ruling that imprisonment is illegal and therefore null and void. We want also the court to rule on the applicability of the SOTO law even in congressional hearings.
Shield law.
And we want the court to declare that the manner by which Badoy was cited in legislative contempt was a grave violation of our due process rights, no? Especially since the question inquired about was completely foreign to the legislative inquiry.
Well, you have to school me here. This is your field. Do you think the Supreme Court will, how will it act? I mean, you're more familiar with that than most people are.
I can't second guess because
of course, but speaking about
Yeah.
what is possible within the law.
Well, the court has repeatedly said, and it said so in Ong, that is why they ruled, even if Ong had already been released, and it was a petition for habeas corpus, that they will rule on, number one, very important issues involving violations of the Constitution, especially if it is capable of repetition and yet evasive of judicial review. And I dare say that what Congress did, release them a day after the petition was filed, it's one of those instances because clearly by releasing them, they wanted to render the petition moot and academic because they thought perhaps that we were only filing a petition for habeas corpus, not knowing that we coupled it with certiorari, because the issue of the SOTO law and due process rights will continue to be justiciable despite their release.
And things are very fluid now. I mean, we just heard of the indefinite suspension this week. Is there, another legal remedy that you think, SMNI can look at, or
not SMNI,
or maybe the people who are concerned about press freedom?
SMNI is doing what it can. Its lawyers went to the Court of Appeals because of a rule that decisions of quasi-judicial bodies must be filed, must be questioned before the Court of Appeals. They went there. Unfortunately, it was not a speedy and adequate remedy because it was dismissed on the basis that they failed to file a motion for reconsideration before the NTC to give it an opportunity to correct itself. But you see, they imposed a 30-day preventive suspension without hearing even the side of SMNI. What's there to be corrected, for crying out loud? That's patently illegal. Because they were already convicted before they were even informed of the charges against them and before they were accorded the right to be heard. And yet that was the ruling of the Court of Appeals. So what happened? Nothing. The suspension was implemented. Every minute of suppression of freedom of expression is a violation of a fundamental and a sacred constitutional right. So every minute that we are not able to air is a violation not only of the rights of SMNI and the journalists behind SMNI, but the right of the people to information. So the Court of Appeal should have acted on it. And since, unfortunately, SMNI is still in the process of questioning the NTC decision, nothing prevents you and I from going to court and alleging we are hosts of programs which cannot be seen by people now because we're off the air because of the whimsical decision of the NTC. Our right to freedom of expression, our right to freedom of the press is being violated independent of the rights of SMNI. And that's what you and I will do. Again... Right? You will join us. You know why I'm asking you? Because having represented many journalists before, and every issue of journalists, not every, but most of the issues that I had, I was there to defend them. But some journalists would say, we should not join because we should not be the story. I think when it comes to freedom of the press itself, should be a natural advocacy for journalists.
You caught me off guard there because I was trying to frame a question and I was trying to bring back, ABS-CBN into that question. And I was going to ask whether or not you see any parallelism, between, what you're talking about, in the defending press freedom, and then maybe what ABS-CBN had because in my view there were two different things. I agree with you.
It's not apples to apples.
And in my view, it wasn't the journalists who failed, but it was management that failed the journalist in a sense. But at the end of it, it's still journalism that suffers, right? And I was just wondering if you see any parallelism there, but at the same time, people would probably take you to task because say, well, how come you weren't so noisy when all of these things were happening before with ABS-CBN?
Well, because I was presidential spokesperson then. And the position of the president is the decision to grant a franchise is not that of the executive, it is that of Congress. Only Congress can grant that franchise, And remember, because a franchise is a sine qua non requirement for broadcast to happen, then you must comply with it, no, before you can allege violation of rights. Whereas here, we have an existing franchise, for crying out loud. We've not been heard. They have alleged that we violated terms of our franchise. No one has heard us. They put us on preventive suspension and now on indefinite suspension. So certainly, the analogy there is perhaps journalists were in fact silenced. But that is because management, in the case of ABS-CBN, forgot or overlooked the fact that before you could exercise a right, there's a sine qua non requirement of a franchise. Whereas here, we have that franchise. And while the state has, to some extent, the power to control the franchise because it owns the airwaves, it begins and ends there. Because they also have to recognize now that freedom of expression and freedom of the press are preferred rights in the hierarchy of rights in this country.
From a legal historical perspective, would you say that this is somehow unprecedented? You know what's
unprecedented? Not even during times of martial law did this happen. There was, the decision of dance. There was at least a resort to a hearing first by the NTC before they were shut down. It was never an instance where they were just shut down. Because even during martial law, the jurisprudence has always been the onus is on government to prove a government interest that will be served by shutting down or by shutting up a journalist or a citizen from exercising their freedom of expression. So it's reversed. The burden is on the side of government.
You're guilty first, right?
Yes. So let them justify first why they want to suppress rather than asking the journalists why they should exercise the right.
Now, let me ask you to put your political hat back on. Would you say that this is something that is temporary because of maybe political developments or maybe even aspirations? Or do you think this is something that's here to stay, what you're seeing now? I mean...
It is here to stay for as long as Speaker Romualdez is in power and for as long as the President does not assert his powers over the Speaker. Unless the President actually shows that he's in control, Speaker Romualdez will continue not only to suppress SMNI but to chill other media installations against criticizing him. And that is why the President has to act soon. Tell Speaker who's in control. Because unless you do so, it's very clear he's not in control.